So today what we're going to talk about, as Scott mentioned, is cross-examination, and this is a topic that's a little bit unlike what we just had with the taxes. I know a lot of us don't feel like we're very expert in dealing with taxes and the money matters. I think more of us feel like we know what we're doing when it comes to direct and cross-examination. So as we talk about it today, if you hear something that you want to participate with, if there's something you want to push back with, if you want to have a sort of a conversation about it, please let us know. We want as much participation as we can get. So the first question sort of is, why even examine witnesses in court? You know, you would think that we could do things by affidavit. Why not write things out, notarize it, swear, whatever you want to do, submit it to the court, and let the court make a ruling? Well, part of the reason is you want to have that person in court, right? The ability to cross-examine the person, to impeach, to show the bias, to let the judge lay eyes on the witness. Those are all the reasons why we don't have just a more sterile environment of affidavits. So cross-examination exposes the truth of the matter. At least that's the goal. That's why we do the impeachment. But which truth, right? Because we all have facts, and facts are hopefully things that we can document and prove, but the facts work together to tell a bigger narrative story, which is what presents the truth. And we each have our own truth in terms of how we see the facts and contextualize it. So part of the reason why we're going to do this cross-examination is to expose the truth, to whittle away at the assumptions, at the biases, all of that to get to what the truth may be. So in dealing with cross-examination today, we're going to talk about some key principles. Some of the terms are things that we just use, but some of them I think you'll understand as well. And we'll go through each of these in turn. The first is the idea of an offensive and a defensive cross. And people call things different things, but when I think of an offensive cross-examination, what I think about is taking a hostile party, putting them on as my witness, and getting everything I can out of them. Now, I don't know if you guys do this or not, but I like to be the petitioner as often as possible. But then if I can, I like to put on the opposing party and get out as much as I can through the opposing party first. And I do that because it's just so much more credible. A lot of the facts that we have will be indisputable facts, right? We all know the age of the children perhaps, when the marriage occurred. If you can get the opposing party on the stand, get out these indisputable facts through that person, you can get them comfortable answering your questions. There's no real challenge. And then if you've done thorough discovery, then you can also potentially have a long list of things that are negative facts for them or positive facts for you that you'll have the ability to go through and get them to say. A fact that is negative for them and positive for you that comes out of your own client is fine, and it's great. But if you can get they themselves, the opposing party, to say what's bad about themselves or what's good about your person, it carries even more weight. Now, there's risks inherent in doing that, but the offensive and defensive cross, I think, are really helpful. A defensive cross is when you're doing more damage control. This is sort of what we think of normally. They put on their witness. You're going to patch it up. You're trying to correct any fallacies that were laid out. You're trying to help rehabilitate your own client. That's fine, too. Defensive cross is great. You can do a lot of good work there. Offensive cross, I think, is a lot more fun.
So when you're thinking about, obviously if you're not the petitioner, then you have to do a defensive cross, but that's not necessarily a bad thing. A lot of times you can take the opportunity on your defensive cross to still shake things up. You can chip away at their direct. You can repair, discount, or mitigate any damage that they've done on their direct. And you can also still take the opportunity to impeach them. So while offensive cross is arguably more fun because you get the judge right away in the mindset of, oh, I have to pay attention because this witness has lied before, defensive cross can be just as impactful. For offensive cross, you also want to keep in mind to only do it when you know it's really going to make an impact. So if you know that it's really going to discount their credibility or make the judge pay attention and wake up and say, hey, this witness can't be trusted. If you're thinking about doing an offensive cross, but there's a risk that it's not going to have that impact, or there's a risk that you may just confuse things, then I would stick to the defensive cross instead of going with an offensive cross.
And there's some examples, some quick examples of what you might use an offensive cross for. I think a great one is child support contempt. Because if you think about it, let's say that you're bringing the contempt action, you can put on the opposing party, the contendor, and say, okay, there was an order in place. The order required you to do X, Y, and Z. You haven't done X, Y, and Z. You've essentially made your case right there. Why not do it through them if you have indisputable facts that demonstrate that's the case? Now, Obviously, they're going to have excuses. They're going to have reasons why they say they shouldn't be found in contempt, even if they didn't do what the order said. But if you've conducted thorough discovery, then often you're going to know what those things are too. And there's not a problem in putting those on and dealing with them in your offensive cross of them. So child support contempt is a fairly simple one to use this on. Custody and visitation modification, that can be a little bit more complicated, but a lot more powerful. That's where if you can really have some negative facts that they have to admit to, it's great to get it out through them. So those are, I think, two ends of a spectrum. The child support contempt is, I think, a fairly sterile, straightforward one, and then the custody and visitation modification can be more complicated. Now, the next idea that we want to talk about is making sure that we don't do any harm. There's a lot of risk inherent in doing this sort of cross-examination, whether it's the offensive cross or the defensive cross. One of the biggest risks is that the witness is going to take control. Right? You don't want them to take control of the situation and then run away. Maybe you thought the facts were X, but they were actually Y, and you didn't properly prepare for that. That's another really bad situation in which they're going to run away with you. So there are risks involved, but there are also rewards. The rewards that we've already mentioned are, if you can get them to talk about it, it's even more credible. If they say the negative things about themselves, it's even more credible. And also, if they're going to be openly hostile to you, which hopefully they are, then you not only get out those facts that you like, but also the judge is getting an indication of their demeanor, their temperament, and this creating the context in which all the other facts are going to be found.
So when you're thinking about do no harm, this is something that you always want to keep in mind. You never, never, never ask open-ended questions on cross. So never start with who, what, where, when, why, please explain. Those are awful questions to ask. You just want to lead. It's essentially making a statement, but that statement just happens to have a question mark at the end of that. And that will help you keep things clear and concise and go within your thread and your story.
So the next idea is to make sure that you're going to tell your story through the witness. Because we've talked in the beginning about, there's truth out there, and we have facts that work together to form the truth, and you have your truth and they have theirs. You want to tell your story through the witness. And there's an example here, a video that I want to show just very briefly of how I like to envision cross-examination, what I think at its acme, what it's supposed to be.
Thank you. Now, I'm always sort of hunting for the perfect puppet, and I need another volunteer, and I wonder if I could borrow you on the end. What's your name?
It's Luke.
Luke.
Luke, yeah.
So what do you do, Luke?
I'm a student.
You're a student. Excellent. Can we give it up for Luke, please? Come on up. Thank you. Now, could you stand on that side of me? So, Luke, I'm just going to give you a slight makeover with this mask here. Take your glasses off. Thank you. And, can you see?
Yeah.
Now, this is just a simple mask. It's going to take the heat off you. You're right. All right. Are you comfortable? Oh, yes, I'm loving it. Oh, this is classic. Okay. Oh, I wasn't expecting this. So, Luke, yes. Are you happy to be here? You're okay? Yes, I'm delighted with the way things are going so far. Okay, good. Yes, in fact, I'm really glad you got me up here. Why is that, Luke? Because I'd like to show you all my dance moves.
All right, so hopefully that's what we're doing in cross-examination, right? We're bringing the person up onto the stand, we're putting a mask on them, and we're telling our story through their mouth. And the body language, I think, is really instructive there, too. She's having a great time. Like, that's what she is meant to do. And he looks dejected. So if you can get that sort of dichotomous relationship in the cross-examination where you're having a great time, you're comfortable, you're getting what you want done, they're feeling dejected like they have no control of the situation, that's perfect, especially if you're using it to bring the truth to the court. Right? It's not just for the fun of it. It's because this is a really great way to bring the knowledge the court needs in a way that's useful for the court. Now, one of the first things you have to do when you're telling your story through the witness is to make sure that you are taking control of the situation. And how do you take control? That's a kind of a difficult thing sometimes. One of the first things you want to do is be proficient. Proficiency is the greatest way to take control. If you get up there and it's obvious that you don't know what you're doing, then the witness is going to sense that. And they're going to start to think, well, this person doesn't know what they're doing and asking me questions. I don't have to really be afraid of them. I can pretty much do what I want. So proficiency is one of the best ways to gain control from the beginning. Another is body language. We all have different styles. I don't know about you guys, but when I'm asking questions on cross-examination and I feel like I'm getting answers that are not the truth or getting answers that are evasive, I tend to get a little bit judgy in my posture. So I might cross my arms, might give a little side eye. Whatever it is, I find that I do the same thing sort of over and over and over again. So your body language, your tone of voice, all of these things are ways in which you can take control. Now, I practice in Tulsa, Oklahoma. I'm sure that what judges prefer here is different than what judges prefer in Tulsa. But I have to know my judge. And I work in Tulsa and I work in counties outside of Tulsa, which are much smaller. So you have to know the judge where you are and what the judge likes. You don't want to off-put the judge trying to get the information out there. Another way to gain control is through word choice, right? So short questions, one fact each. Limit the questions as much as you can. If you can have just a couple words in your question, that's great, because you're trying to tell the story. What I notice a lot of people do when they're asking questions on cross-examination is they put in a lot of those connector or filler words. They'll say, so XYZ, or they'll add in correct at the end. Some words that you don't need to have. Because typically, if you've got the person with you, if you ask them enough questions that they had to answer yes to beforehand, they're going to be on that sort of yes train. You don't have to give them a clue with every question that you're asking them a question. They know that you're asking questions. So saying those additional filler or connector words tends to disrupt the narrative that you're trying to create for the court. So instead of saying, your name is Bill, correct? You can just say, oh, your name is Bill. And if the person is with you, then they'll go ahead and answer. If not, you have to get them with you. But that's a great way to start doing it. And then psychologically, we all have different presences, right? My physical presence is different than Bridget's and different than yours. If I have a witness who is a smaller person, or maybe one who is frail, I'm not going to try to tower over that person. I don't want to create the narrative of being physically aggressive, so I'll make myself smaller. Right? You have to make sure that your physical presence aligns with the witness that you have, so that you're creating the proper meta-narrative for the court too. You have to understand that the judge is seeing you and them, and it's not just what's being said, it's what's being seen. All right, now the next thing is to limit your objectives. So because cross-examination is inherently difficult and dangerous, one of the things that you want to do is have a narrow focus. I don't know if any of y'all have seen The Patriot, that movie with Mel Gibson. Anybody see that?
From like 20 years ago.
It's not that long ago. So in The Patriot, it's got one of the worst child abuse scenes where he's taking his little boys after the British soldiers and they're going to shoot them. And he's saying to his kids, now remember what I told you, aim small, miss small. And that's something in marksmanship, right? If you are looking at a target, let's say that you're looking to shoot me with an arrow. Right, if you're saying, oh, I generally want to shoot him with an arrow, and this is my whole target, if you miss, you're maybe way off to the side. But if you're saying, I want to shoot that button right there on his stomach, well, then if you miss, then maybe you're off, but you're still on my torso. So it's the idea of aim small, miss small. Have a narrow objective, be tightly focused, so even if you mess up, you're still within a general channel that you want to be in. So if you limit your objectives, that means that you know in advance what you want to get. You know what documentation you have or other bits of evidence to support whatever impeachment you try to do. And even if you mess up a little bit, even if you ask a question you shouldn't have asked, if you've tightly focused in on what you want to accomplish, you're probably going to be okay. If you're just wide-flinging and don't have a plan to begin with, if you haven't aimed small, then when you miss, you might be all over the place.
So when you're thinking about your cross, I'm one of those people that likes to write out everything that I'm going to go through. Now that doesn't mean I'm just staring at the paper and I'm tied to my script. You always want to, keep your mind open to ask follow-up questions if you think they're going to be good. But you want to have everything ready to go. So you have your story in mind, your facts that you're going to get out. If you know that your witness is going to lie, you want to have your deposition marked up with the page number of where you're going to impeach them. You want to have your discovery responses marked up with where you're going to impeach them. And you want to have the copies ready so that when you hear that lie that you've anticipated is going to come, you can take it out and say, Your Honor, may I approach? You give a copy to opposing counsel, you give a copy to the judge, and then you approach the witness. And not only does that keep things flowing, but if you have a judge who's paying attention, in their mind, they're probably going to be like, she knew that this witness was going to lie about this. I wonder what else has been going on in the background here that caused her to think that. And that is another layer of the judge saying, can I really trust what that witness is saying if we've got all these lies on the record? So I wanted to give like a quick little example of limiting your objectives, because it's very tempting to like just add in that final question that basically says, so I was right, or so you're a liar, or so you're awful. So an example of this would be parents going through a divorce, and the children are really struggling, and it's clear from the facts that have already been established that they really need therapy. Dad's been trying to get kids into therapy, mom hasn't. So when you approach mom on cross, you're going to say things like, the father wants the children to go to therapy. You have not agreed to the therapist he selected. You have not proposed another therapist. You have not enrolled the children in therapy. You go to therapy yourself to help with your own struggles. And then after that, it can be really tempting to just say, so you don't want your children to go to therapy. Or, so your children don't deserve the same help that you're getting? Don't do that. You save that for your closing. You save that for your proposed findings. You've already got the facts out there that mom didn't do this, mom didn't do this. She does it for herself, not for the kids. So you wrap it up there. You don't need to add that final last question. Because again, if mom's defensive, she could be like, well, that's not true. I didn't think that, blah, 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 blah. So that's a good way to just limit your objectives, get in, get out. You've made your point. The judge knows, hey, there's something wrong with mom.
And that ties in really well to the next slide that we have, which is talking about quitting while the quitting's good. Now, a lot of times folks get into sunk costs. And I don't know if you all remember this, but several years ago, they were talking about the International Space Station. And it's decrepit, it needed to be repaired, or they need to just get rid of it and move on to something else. And in looking at the news, what they were saying in Congress was, well, we've put so much money into the space station, we can't just let it fall apart now. But that's the epitome of a sunk cost fallacy, right? Just because you've expended resources in something doesn't mean it deserves future resources being expended on it. And the same thing happens with your cross-examination. Sometimes you may get into a cross-examination and realize that you're stuck, right? Maybe you didn't plan properly and this is turning against you, you've lost control. It's okay to know in your mind, I really messed this up, I'm out. To stop, see if you can get something good for yourself at the end, like maybe one last thing if you think you can, but get out, quit while the quitting's good. Now, there's also the saying that you never want to ask that one last question that goes too far, but this is where I kind of disagree. I feel like, and this may be subject to disagreement here too, I feel like if you're properly prepared, if you've done your discovery, if you've done depositions, which I hear are done regularly here, not so much in some of the other jurisdictions where I've been, then I feel like you know what they're going to say, right? So for that example of the child support contempt, you had the order in place, you didn't abide by the order, that's contempt unless you can show that there's some excuse. If you know what their excuse is going to be, I would much rather get their excuse or their justification out while I have control of the examination. I know it's going to come out as soon as I give up the witness, so why not bring it out while I'm in control and can do something about it? That way it doesn't look like I've hidden from that fact. It's a negative fact for me, perhaps. I'm going to bring it out and deal with it. I'm going to try to stick it within a good news sandwich. I always want to make sure that I start strong and end strong and maybe have my weaker stuff in the middle. But I don't think it's useful to avoid questions that you know are going to come as soon as you sit down. So quit while the quitting's good, but not to the detriment of your case. All right, then the next thing is to make sure that you use what you've got, because there's risk inherent in the cross-examination, right? You can lose control, you can say something stupid, the case can get away from you. So if you're going to go through that risk, then you've got to make sure that you capitalize on your investment by using what you've got. One of the ways in which you do that is if you are given the opportunity for a closing argument to have actually listened to what they were telling you during the cross-examination, which is, I think, a prerequisite for any good cross-examination, and then to tie it together in your closing statement, if you get one. Make sure that you connect those dots. We talked about how you don't want to necessarily do that connecting function in the midst of your cross-examination because it gives the witness a chance to move away from what they said before. It gives them a chance to sort of swirl out. So at the end, if you're able to make a closing statement, that's when you connect the dots. That's where you make things clear for the judge that perhaps it wasn't clear before. But you've got to use what you got.
Yeah. And even if you don't get to do a closing, do you guys do proposed findings at the end of your trials or evidentiary hearings?
Sometimes.
Sometimes. So in my jurisdiction, we always do that. But that's your opportunity. You can treat that like a closing. That's where you can wrap it up in a pretty little bow for the judge and deliver it on a silver platter.
All right, so next we're going to talk about how you take control. And we've talked about this a little bit already. But one of the first things that we're going to think about is the fact that a hostile witness is in fact hostile. So especially in the kind of law that we do, with the family law, oftentimes there are high emotions that are involved. People have deep-seated thoughts of themselves being a good parent, feeling that the other person is saying that they're not a good parent, want to take them away from their children. So the person is hostile. And you can never forget that. So when you're going to cross-examine the opposing party, you have to recognize that this is a person who's probably not an idiot, who probably has had some coaching or training about how to be a witness, and who has an objective that's very different than yours. Their objective is to get their story out in a way that suits them. Your objective is to not let that happen. So I think it's always important to remember, no matter how they come across, whether they're coming across as being kind or considerate, they really don't like you, and if they can stab you in the neck, they're going to do it.
Yeah. And so another thing, and Ron touched on this a little bit already, but how you approach your witness really depends on how they've acted on direct or how their position is if you're doing an offensive cross. So if you have, a mom who's being really tearful and sympathetic, I'm not going to go in there strong and attacking. I'm going to convey sympathy. I'm going to take a softer approach. I'm going to, bend my head a little and nod my head and say, I understand, I hear you. If you have a witness who's being stubborn and belligerent and just saying, no, taking a snotty tone, then at that point you can be a little bit more forceful and really convey to the judge, hey, pay attention to this. As a female too, you can do a couple things if you're crossing a male witness who's maybe being, very strong and forceful. You can take the opportunity to also be strong and forceful back, or you can be softer and a little bit more quiet, and maybe the judge will seem like this witness is bullying this attorney. I don't like that guy. He's being mean. He's being overly aggressive. So, as a female attorney, there's some different ways you can play with those witnesses.
Now, the next thing is the fact that he or she, whoever the witness is going to tell the story their own way, and we've already talked about this a little bit, so I'm not going to get into this too much. But one of the ways to keep them on track with what you're saying is to use headnotes, for example, to let the court and the witness know this is what we're talking about now. And I think everyone likes organization. I think judges are not necessarily there for the entertainment. They have a job. They want to get it done. They want everybody to be efficient and have respect for the system. And if you have good headnotes laid out, and then the person who you're questioning tries to go outside of the realm of what obviously it is that you're talking about, I think that person looks as if they are not participating well within the system. It's a way in which they're trying to tell their story regardless of what the court has set up for them, and it's going to look negatively on them.
So talking about headnotes, I just wanted to give you guys some examples because, it's kind of that thing that's out there, but in my practice, I see a lot of people forget to use them. But it's a great way to keep the judge on task for you to notify the judge, hey, I'm going to switch to this topic. So if you're talking about a custody case, you can say, let's talk about Susie's grades, or I'm going to ask you about your before school routine. Let's talk about John's relationship with his father. Let's talk about Joe's absences from school. It's a way for you to keep your organization, but also let the judge know, this is probably going to be interesting to me, so I'm going to start paying attention. Because you all have those judges where you just look up and they're like playing on their computer, their mind's wandering. So you just want to grab them back in and say, hey, I'm switching topics. Let's go.
All right, so next we're talking about making the witness admit your good facts. And we've mentioned this before already. So just very briefly, this is one of the keys. If you're doing a cross-examination, if you're doing the offensive cross, a key is to make sure that you have really well organized out what it is you want them to admit. It's something that they can't get away from, and that you're prepared with every single piece of documentation, photograph, whatever it may be, that's going to impeach the person if they don't admit what your good fact is. Now, one of the ways in which you can get them to do that is the looping technique. Now, looping means different things to different people. One way to think about looping is if you have a recording that's playing over and over and over again, that's on a loop, and so that's one way of looping. But what we're talking about in this case is where you take individual facts that have been admitted and you build them together to make a longer chain that is something new that hasn't been admitted or stated previously, but is inescapable because of the prior answers. And so I know that's a lot. So here's an example. Now this is from a transcript of an actual case, and this was a case in which Child Protective Services had taken the children from the home and had removed them. And instead of removing them to a friend or family placement, because no option like that was given by the mother, they were placed into a really nasty facility in Oklahoma. And there are a lot of those, unfortunately. So in this case, this was actually one of my transcripts. It was asking the mother about that friend or family placement. So I asked her, who watched the kids for you?
Friends. I got a job where I could work overnight, and they would be asleep, and a friend would stay at the house and watch the kids.
So you had friends that you trusted to watch them while you were working?
Yes.
And how many friends did you have like that?
A couple.
They were good friends?
Yes.
Close friends?
Yes.
And the kids liked them?
Yes.
And they really looked out for and protected the kids?
Yes.
So you did not provide social services the names of your good, close, and trusted friends who historically looked out for and protected the kids?
No.
All right. So that's an example of looping. I think this was a good example because the initial questions that were asked of her made her feel good about what she was saying. This is a mother who had already been sort of beaten down multiple times because she had had lots of issues. And so she wanted to get out the fact that she had been working. That was a good fact for her. And she wanted to get out the fact that she had a support network of friends. That was a good fact for her too. And that these friends were trustworthy people and the kids really liked them. So all of those initial facts were good facts for her. It was just that when you put all the facts in combination in the context of no friend or family placement and instead a facility placement, it becomes negative. So if you can use a looping example to build up those initial facts that are, especially if they're good for the person, and then tie them together in a new thing that's bad for them, that's a great way to use that looping technique. Now, this next thing is something that I actually have a problem with, I found out. Not attacking or mocking the witness. I've given a presentation like this before, and I said, okay, so let's do an example. And we brought a witness, a fake witness up, and I cross-examined the witness. And I said, see, you want to make sure that you don't attack or mock. And the people in that was like, hold on, you totally mocked her and were attacking. And I didn't realize it. So I learned something about my own style that I was coming across in a way that I didn't intend. And it's dangerous because if you are going to go up against a witness, especially given whatever the social connection is, like if I'm going against cross-examining a mother, especially a young mother or a small person, and I'm coming across as imposing, you're going to have that sort of incidental damage that you don't want to your reputation and also potentially the reputation of your client. And this gets into the idea of integral versus incidental emotions. So, excuse me, if you have an incidental emotion, that is something that can affect the decision-making process of the judge, but it's not directly tied to what the decision is. So, for example, if I'm cross-examining someone and I come across as a bully, like Bridget was talking about previously, then the judge may say, okay, I see that you're a bully in this situation. You're representing this person. So I may transfer my thought of you being a bully or a jerk onto your client. And that can be a form of incidental emotional transfers, like this transitive property of being a jerk. You don't want that to happen. Now, there's different types of emotions that affect decision-making too, and those are integral, things that actually have to do with what the decision is. And you have to remember that facts are really pesky things. Once a fact gets in somebody's head, it's hard to dislodge it, and it's almost impossible sometimes to dislodge a fact with another fact, especially if they're completely opposite, because the person who's deciding which fact to believe doesn't necessarily have a frame of reference that lets them do it. It's much more helpful if you can have an emotion to dislodge the fact. And so, for example, let's say that you have a case in which you have a mother, and it's a custody case, and she has been put on this pedestal. Maybe she put herself on the pedestal. Maybe it's clear from prior rulings that the judge has felt that she was on a pedestal. If you can have that situation and you can show the judge that she's not trustworthy, that she's acted against the children's best interest, that she's not the person who should be on a pedestal, then you can possibly evoke in the judge some disgust towards her, right? The people that we set up on pedestals and then knock off, we really don't like. And if you have that feeling of disgust towards them, then sometimes it might be willing to push them away a little bit. If they have a plan that they want and you're disgusted by it, our disgust reaction is to get that away from me. It's actually biological. It's related to us eating foods and not wanting to have a food that's going to poison us. And it's the same sort of emotional response that we have. You can do the same thing with anger, right? You can do the same thing with fear. I mean, I imagine that for judges, one of the things that they're most afraid of is making a decision that hurts a child. And so if you can help the judge understand that there's reason to be fearful, then that may help dislodge a fact that they had in their mind previously. But pride is also a fact as well. So if you can, let's say that you have a client who has a lot of issues, maybe had some drug issues, maybe had some violence issues, and previously the court had imposed some remedies for that, maybe drug counseling, anger management. If you can show the court, hey judge, you were right. You put this person in anger management, it's helped them. You've put them in rehabilitation, it's helped them. They're doing what you said, and because of you and your recommendations, they're a better person. Then I think the judge might take some ownership in that and say, okay, this has happened. This person has made progress. I'm proud of this person. Let's go a little bit further out on the road and see what we can do. There's basis now to do that. So those are the types of integral emotions that effectively direct the decision-making process that you want to elicit to try to dislodge facts that are going to be hard to dislodge otherwise. All right, the next thing is making the judge the enforcer. I think too often people will start to bicker with the person that they're that they're cross-examining. The person won't answer the question directly, they won't answer just yes or no, and you kind of get frustrated by it sometimes. And you want to force them to answer yes or no. Now, it's my understanding that in these counties around St. Louis that it's not always the case that the judge will make the person answer yes or no. And so if that's not the case, and I think it's probably judge by judge as it is everywhere, if it's not the case that the judge will make the person answer yes or no, well then you have to do a little bit more work. But if the judge is someone who will do that, then you can make the judge the enforcer. It's the judge's courtroom, it's not ours. So it's not up for us to make the rules and enforce the rules. So if it's the judge's rule that they answer yes or no, then politely ask the judge to enforce that rule. If it's not their rule, then you can do something else. But don't ever get into a fist fight with the witness. Don't bicker with them because you're never going to win. You're the professional, they're not. You have an obligation to act differently.
We should say verbal fist fight.
Yes. Not to imply the other one's okay. Right.
So before you're actually asking for the judge's help in enforcing, there's a few ways that you can just try to get the witness to answer your question without necessarily bickering with them or starting an argument. So questions that I like to ask, you ask a question, they don't answer it, say, maybe you didn't understand my question, let me ask it again. Or sometimes I'll just repeat the question and pause and wait. Or if they're still not answering, I'll say, this is a yes or no question, so if you could just listen carefully and then please answer. And then if that's not working, at that point, in my jurisdiction, judges are pretty tired of the witness not answering the question, and they'll be more than happy to step in and tell the witness to just answer the question. And if it keeps happening, at that point, they're frustrated with the witness, and that can transfer into positive feelings towards your client as well.
And that's another way, I think, to make the judge take ownership. Because I feel like if the court has established a rule in that particular setting on that day that you're going to answer yes or no, and then the person isn't answering yes or no, then I think it's a fair question for the judge to have. If they can't even control themselves for 20 minutes here with the rules that I've set up, how are they going to control themselves later? How are they going to interact in transfers or conversations about school or whatever it is? So I feel like that's a fair question, and it's a way to bring it into the court's frame of reference. So next, we're going to talk about understanding and clarifying the record. So this goes back to the idea that there's risk involved in the cross-examination, and you want to be able to use what you've got, and one of the ways in which you can do that is to make sure that you know what record that you're creating. Oftentimes, what you'll see if you go to appeal is that even if it's your own case, you didn't quite get what you thought you had. And it's easy to get lost in the moment and to say, oh, well, I thought they said that, or I thought I preserved that in my objection, or I thought I made that proffer. So to be really careful to make sure that you understand what the record is. Now, if you do have the situation in which the judge will permit you to make him say yes or no, and then will allow you to give a motion to strike any portion of the record that was non-responsive, you have to really stop and think. Sometimes you don't want to strike it, right? Because sometimes the person will go beyond yes or no, and it's something that's good for you. So it's really important to listen. If it's not good for you and you want to strike, you want to make sure that you're striking only the portion that's not good. Maybe some of it was and some of it wasn't. So making sure that you understand what's been said, that you're listening, and that you clarify the record, always thinking, well, what if I had to take this on appeal? Or what if I'm looking at this transcript 2 years from now? Am I going to see what I want to see? That's a really important part.
Yeah, and I actually, this is really important. I actually just had this happen on appeal that I handled. Opposing counsel was a very seasoned attorney. It was an alimony case. Our expert witness did a cash flow analysis, was testifying to the client's need, the other party's ability to pay, and I asked him, based on your analysis, what does this tell the court? And he flat out said, it says that Mr. Client has a need for spousal maintenance and Miss Client has a clear ability to pay. The other side objected, the court sustained it, but she didn't move to strike. So this case is up for appeal, and that expert's opinion is on the record in front of the Court of Appeals. So, you know, that just goes to show that you really do have to pay attention. Another thing that is my favorite motto on cross is never ask a question that you don't know the answer to. You know, if you don't know what they're going to say, or if there's even a small potential that it's going to hurt your case, just don't ask it.
All right, so what we're going to do next is to get into a fact pattern that we prepared that we thought we could talk about and maybe try out. But before we do that, does anyone have any questions or thoughts or pushback on anything we've said? Everything was perfect.
Awesome.
All right, so we have a fact pattern that we'd like to get into. So in this fact pattern, we have a custody situation. This is a motion to modify. So currently, under the fact pattern, mom has physical custody, but there's some issues. Mom was fired from her job. She came to work drunk on 3 different occasions, and she was charged with a DUI after dropping off the kid at school. She ran into a fire hydrant, probably not the best. Now, dad does have parenting time. He's got every other Friday evening to Monday morning return to school, and he's got every Wednesday evening. All right, so the basic facts, mom has primary, dad has some parenting time, mom's got a drinking issue. Nothing negative about dad so far. Now, the son, and we're going to call this guy John Doe, John's been having some trouble in school. We can look and see when dad has custody, when mom has custody, and how many tardies and absences there have been. And there's something going on with mom on Wednesday mornings because that kid cannot get to school. There have been some absences as well. And so we're starting to see some degradation in the kid's school performance, which is going to be part of the basis for this motion to modify. We've got 21 unexcused absences, and the truancy officer is about to come after mom. There's a problem with homework not being turned in on Thursdays, which is an issue for dad because that's after dad had the child on Wednesdays. And then the grades are falling. John had A's before the custody arrangement got put into place, and now he's getting down to C's. And we've got a report card as well. So I don't know how well you can see the report card, hopefully pretty well. We've got some administrative notes at the bottom there that maybe the principal is giving a little bit of input. And then we're assuming that there's a custodian of records affidavit that has been used to have this document prepared for the court. So what we'd like to do is just run through potentially some questions that could be used with this. The first thing we're going to do is maybe go through a cross of mom based on these facts and just show how a cross might be done on it. And if you all think that there's something objectionable that's said, or if you think that a question isn't very good, or whatever you think, stop us and let us know, right? So we can discuss. All right, so this is our alcoholic mom. No typecasting. So we start off with a question. So John is in your custody for nearly all school days.
Yes.
And the father has John only on Monday mornings every other week.
Yes.
So in a 2-week period, you've got 9 school days in which you have John and dad has 1.
Yes.
All right, now, John has no tardies on Mondays this year.
I don't think so.
You're not sure when he's tardy?
No, I mean, I know,
So John has no tardies on Mondays this year?
probably,
All right, are you sure?
sure.
Okay. Have you seen his statement of the tardies and absences that he's had broken down by day?
Yeah, I think I got that.
All right, so it's pretty clear then, right? Do you need to see that? Let's see if it refreshes your recollection. Have you seen this document before?
Yeah,
Do you recognize it?
I do.
Is that our stipulated fact that there are no tardies on Mondays?
Yes,
All right, so John has not been tardy at school on Monday this year.
sure.
All right. Now, John has been tardy to school 35 other times though, right?
If you say so.
John's been tardy 35 other times, right?
I mean, I guess.
Are you not sure?
Sounds right.
Would you like me to refresh your recollection again?
No, it's
Okay.
fine, yes.
All right. Now, those 35 times were days when you had John.
Probably.
Okay. So can I take that as a yes?
Yes.
All right, now this would be great if we were in a jurisdiction where the judge will force yes or no. I would have already done that. I would have asked, but I'm assuming that we're not. So I'm doing the best with a recalcitrant witness who's smarter than I am. All right, now, you also have a problem with drinking during weekdays, don't you?
I wouldn't call it a problem.
Okay. Do you in fact drink during the week?
I have.
And you've in fact taken John to school while drunk?
I wouldn't say I was drunk, no.
When you ran into the fire hydrant and got charged with the DUI, were you drunk?
I wouldn't say I was drunk, no.
Okay. Did anyone else say that you were drunk?
Well, I mean, the police did.
So there may have been an objection there, right? Certainly an objection there. All right. Now, you were drunk on other weekdays as well, right?
I guess.
Well, when you showed up at work and were drunk, what happened?
I did my job.
Okay. Did your drinking affect your work?
I don't think so. I think it made me better.
And is that why you were fired?
Well, that's what they say.
Okay, so you were fired because you showed up to work drunk.
I mean, that's what they're telling me.
Okay. 3 times.
That's what they say.
Okay. And do you believe that that's the truth?
No. Like I said, I don't think I was drunk.
Okay. All right, now, do you recall the day that you dropped John off at school and then hit the fire hydrant?
I do recall that.
How much did you have to drink that day?
You know, just hardly anything. Nothing.
Nothing outside your normal?
Not much.
Okay. All right, now, also John's grades have gone down since the separation, haven't they?
Yeah, but that's not entirely my fault. I mean, he's dealing with the separation. You know, that's been really hard on him. He's dealing with 2 different households. There's a lot of stress going on in his life. It's not just my fault.
So what do you guys think I should have done there? Stop her? How would you guys recommend stopping her? So we have maybe a move to strike, maybe objection judge, non-responsive, a move to strike the non-responsive portion. Any other ways? What other ways do you guys use to stop a runaway witness? Yes? Put up your hand. Oh, your hand? So sort of that, like, I don't know, do y'all ever do this? Especially if you're at a podium, you've got the witness there, they're running away with you, and you sort of step up and you say, ma'am, you just put your hand up for a second. Does that ever work for you guys? Just the body language of stopping? Another thing that you can do is listen to what they're telling you and use it. So in that instance, what did you tell me?
It's not entirely my fault.
Not entirely her fault. So whose fault is it? Right? So she's talking about fault. She's saying that someone is at fault, but it's not her. Who else could be at fault? So we could ask, is it John's fault?
No, it's not his fault.
Okay. Is it the father's fault?
Yes.
Because he doesn't have John on the school nights.
Yep.
Okay, so maybe he needs to have him on more school nights.
No, I don't think that'll fix it.
Okay. So as you go through on that cross-examination, she sort of got away with us. A great way to do it would be to invoke the judge as the enforcer or to get ahead of her and bring her back into play. Anyone have any suggestions? What kind of questions would you have asked her there? Anyone have any questions that they would ask? Yes, ma'am.
Talk to me about using that term drunk, because I think that gives Bridget a whole lie and it's worse to run through. Well, I wasn't drunk. Now, I don't think I was drunk. The cop thought I was drunk. So I see you falling down a rabbit hole with that term you're using. You want to
Sure.
try to do something else?
Sure. So if I were to ask you, were you drunk?
No, I don't think I was drunk.
What do you think of as drunk?
Can't walk.
Okay, so anything less than not being able to walk is not drunk for you?
Yeah.
So could you be intoxicated but not drunk?
I don't think so.
Do you feel comfortable driving as so long as you're not drunk?
Yeah.
And so you'll often drive when you've had some drinks but you're not drunk?
I'm not drunk, so I'm capable of driving.
Okay. And on the day that you ran into the fire hydrant, were you drunk?
I don't think I was drunk.
Okay. So I might do something like that where if she's using a definition against me, then I'll try to, yes, sir?
The other thing, you could just ask her, did she blow? What did she blow?
Yeah. So how would your courts deal with that? So with a street breathalyzer, those tend to not be admissible as evidence in my jurisdiction. Are they admissible here? Not admissible because they lack the credibility?
Also, in this jurisdiction, you've got a Department of Revenue record for either refusal or taking the test. So you can get that as a business record exception from the state of Missouri, and she says, well, I don't remember. You admit that. But the other thing, I'm kind of surprised that you haven't hit on is, when did this happen? Dropping the child off at school. So you're drunk in the morning as well as at night?
Right.
When did you stop drinking, or have you yet stopped drinking?
Yeah, very good. And how about if a person is that drunk, dropping off at school and losing their job, are they drunk today? Have you been drinking today before you came to court? Questions like that. Anything else? Those are all great. Any other pieces? Yes, sir. Okay, great. Anything else?
Yep.
I would ask what she drinks, how much of what kind of alcohol.
Anything else? So it gives you a lot, doesn't it? And that's why I don't think it's always the case that you want to cut them off at yes or no. Because often what I find is that when someone goes beyond a yes or no, often, especially if they know they're supposed to stick to yes or no, especially if it's been made clear to them, the reason they're going beyond yes or no is because they have a need. There's something that they're concerned about. Maybe they're insecure, maybe they're afraid, and they feel like they have to get this information out. And so if you listen to what they're telling you beyond yes or no, then sometimes what you can get is a sense of what their insecurity is. And once you discover what that insecurity is, then you can go down that path. Sometimes it can be definitional. Well, I don't think I'm drunk unless I can't walk straight. Or maybe it's, there was some other reason that I lost my job. Whatever it is, if you listen to what they tell you beyond yes or no, you get an insight into what their psychological state is, and maybe you can do something with it. All right, anything else on that? All right, so what we're going to do now is maybe goes through some questions that we think are plainly objectionable and see what you all think about the objections.
So this will require audience participation.
So we put some objections up here, just a little bank to maybe help you. Not that you need it, but just to spur your thought. All right, so now. So I'm again asking Mom these questions. So the principal told you that he was going to start truancy proceedings because you failed to get the child to school, right? All right, hearsay from the principal. All right, so you did not get the child to school on 35 occasions, and he has 21 absences on top of that.
Huh?
Is there a problem with that one? Compound. Right, so the problem with compound, obviously, is what are you answering? Which one do I start with? So isn't it conceivable that John would get to school on time if he lived with Dad? Speculate. Awesome. All right, so the fact is, you really couldn't care less whether or not John gets to school on time.
That's not true.
Argumentative. All right. Now, what time do you leave your house? What is that even asking? Right? And what if we say, what time do you leave your house in the morning?
Depends.
a little bit vague, right? We're still not really getting at what we want to get at. We're trying to figure out why are you late to school? So those questions are a little bit vague getting you there. All right, so now you do yoga during the day, right?
Yeah, it's good for you.
What do you think about that? Relevance, right? And how does that advance the ball at all? Give us anything material. All right, how about this? So your attorney told you that you better get your child to school on time, right?
I think that, yeah, he said something about that.
Hearsay? Okay. And also, we're getting into the attorney-client privileged communications. All right, so you're an alcoholic?
No.
What do you think about that? Is that objectionable? What would... So that one I think is an interesting one because the person maybe knows what their own diagnosis is, right? If they've been diagnosed as an alcoholic, they can testify about their own medical condition, potentially. So that one I think is on the edge a little bit. All right, so now you could take some of the facts that we've gotten before and you could do a looping exercise with it as well if you wanted to do so. So you could take some of those facts about the drinking and the hydrant and all of that and tie it into about being intoxicated, taking the child to school, which will get to that point that you were talking about before. All right. Anything further?
No, we could do just some more objections on the directive.
Okay.
If you wanted to do that.
We also have some objection practice that we could do on direct examination as well. So we'll run through some more of these. So you're asking me? Okay.
Yep, okay. So, Mr. Doe, what did the principal say about John's tardies?
Hearsay? All right.
Mr. Doe, why do you think that mom couldn't get the child to school on time?
Speculative.
What did mom say when you asked her about the tardies? Trick question.
Yeah. Yeah, so party statement, right? So no objection on that one.
Your Honor, I would like to admit Exhibit 1, which is the child's report card showing the tardies and the principal's comments.
What do y'all think about that, just out of the blue? We need some foundation on it, right?
Yep. All right, so let's try again. Mr. Doe, I'm showing you what has been marked as Exhibit 1. How did you receive this exhibit?
In the mail.
Your Honor, I'd like to admit Exhibit 1.
Still have a problem? All right. So what do we need to do? All right, we need to build some more foundation, say what kind of record this is, how is it kept. All right.
Yeah. Let's see. Is Miss Doe an alcoholic?
Yeah, I would think so. What about that one? Right, calls for an expert opinion from a lay witness, potentially.
Mr. Doe, what happened the day that Miss Doe hit that fire hydrant?
Well, I heard that she was all over the place. So what's the issue there? Hearsay, and I may not have any personal knowledge. We need to establish first how I know what I know, and then maybe it can come in.
Okay. Mr. Doe, what did John say about his grades dropping?
What do y'all think about that? John's the child. Hearsay. Now, there's an exception in Missouri, but what's that exception for? Sexual abuse of a child? And I was reading up on that because I was looking at the Missouri law, and it appears that it's not just physical touching, it can be any sort of sexual abuse of a child. But other than that, it appears that the hearsay would prevent it.
Mr. Doe, did Miss Doe follow the advice of the principal and start getting the child to school on time?
I don't even know where to start with that one. So what objections do we have there? We've got some foundation, we've got potentially hearsay, we've got, I don't know, compound. We got a bunch right there.
Mr. Doe, will John's exposure to Miss Doe's alcoholism affect his future development?
So the answer is of course, but what about objections on that one? Yeah, it calls for potentially an expert, yep, speculation.
Mr. Doe, what are your concerns about Miss Doe's DWI and John's drop in grades?
What about that? Compound, and then within each one of them is calling for some speculation, potentially.
What do you do on school days?
What do I think about that? Is it potentially relevance, like why are we asking? And also, what about the form of it? What's it asking me to do? Sort of give a narrative of my day. What am I? I'm waking up at 6:30, I'm getting out of bed, I'm stretching, I'm getting a cup of coffee. So it's not really getting to the heart of what we want. It's not taking me down the path at all. Okay, so before we wrap up, anyone have any questions of us or comments, pushback on anything that we said, discussion? Okay, well, thank you guys very much. Hope you all have a great rest of your day.
Thank you.